Okay, I think it's recording. I'll kill myself if it's not. Okay, we're students. I'm visiting with Rex Schulte, who's an attorney in Lincoln, Nebraska. And Rex has, I've worked with him on a couple things. That he did some contract work for me and some early retirement issues that he straightened out that we probably were illegal with our early retirement plan. He's one of the most respected school attorneys in Nebraska, and he always seems to be a year ahead of a lot of people in what he anticipates maybe is going to happen. We're going to talk a little bit about teacher freedoms in this chapter. Rex, how long have you been an attorney?
36 years.
36 years, so you know the route. And I think, if I remember right, you were a teacher for a while.
Yeah, I taught 4 years in the mid-1970s at Omaha Bryan, which is a Omaha Public Schools high school in southern Omaha.
Mm-hmm. And I remember you did a video for us that I still use on teacher evaluations, and I was the fact that your background in teaching, I think, is helpful in that situation. Well, let's talk a little bit about one of the things, and we talk about teacher freedoms, is what is the status of academic freedom in Nebraska? What does that tell me?
Well, let's start off with the concept of public school teachers and what their role is. And the fact that they are K-12 or pre-K public school teachers really impacts the concept of, we're going to call it, academic freedom. Students that attend public schools attend because of compulsory education laws. And compulsory education laws, as all of you know, are laws that require parents to send their children to school, either public, private school, or homeschool them, but nonetheless, they're required to provide an education for their students. Students who therefore attend public schools are there because they're required to be there, and so therefore they are a captive audience. That's different than a student who may be attending a college or university because they're choosing to do that. That's their voluntary choice. So academic freedom then is more limited for public school teachers. And then we get into the concept behind academic freedom is the concept of free speech. And as Dr. Nelson has probably told you or discussed with you, the main case on employee speech was a case decided in 2006 by the United States Supreme Court called Garcetti versus Selvas, and really talked in terms of dividing employee speech into speech on matters of personal interest, which is not protected speech. In other words, if they're talking about their own personal circumstance, their own evaluation, those kinds of things is not protected speech. Speech as a citizen on matters of public concern by an employee are sometimes protected speech. And they also held, and this was the most important aspect of Garcetti, was speech as an employee is not protected, even if on matters of public concern, when the employee speaks on a matter of public concern and does so in the course of his ordinary duties as a government employee, and therefore the First Amendment does not offer that protection. In the end, the concept is, in public education, is the Board of Education is the one who gets to determine what's taught in school. So there is, and the concept behind that, as Judge Courts have said, is that's because they are elected officials, and the public can decide to keep them or get rid of them by way of an election, whereas a tenured teacher or even a probationary teacher is, quote unquote, not elected. So that doesn't mean that you don't have the creative ability to teach. I can tell you, when I taught school, I taught social studies. We addressed I would suppose the concepts of controversial issues. But and one of the things that Dr. Nelson asked me is, well, do you need a controversial issues policy? The answer is you should. And most of your school districts will have a controversial issue policy. And those controversial issue policies really basically say that you're supposed to be careful with regard to how you handle controversial issues. Does that mean you can't discuss them? No, you can discuss them. But remember that you have to discuss them in a neutral manner. If you promote your own personal views, or you direct the instruction toward a particular area of instruction or area of opinion, that may become problematic. That does not mean that you cannot teach or address issues in a manner that is within the framework of your curriculum. For instance, you could discuss the Declaration of Independence, or you could discuss the Constitution and talk about the guarantees and what cases say with regard to the Constitution. I realize that that's limited to maybe to a social studies issue, but also if you're talking about language arts, English, or even issues related to evolution or I'm trying to remember the proper term, but intelligent design or something like that. Addressing those issues within the framework of the curriculum will protect teachers with regard to those issues.
You mentioned the Garcetti case, and I've talked to students about the relationship between administration and teacher is fairly valuable in the court's eyes, correct? Do you see it that way, or?
Yeah, administrators, remember that administrators are the educational leader of a school. Mm-hmm. And administrators should provide guidance to their teachers. For example, what I just said about controversial issues. What we do and what I do as a school attorney is practice preventative law. We work at trying to equip administrators and therefore teachers and board members to avoid legal issues, follow the law, and provide for best practices. Therefore, administrators should be proactive to preempt issues that you have. You know, teachers are like anybody else. They need guidance. How am I supposed to handle certain issues? In-service your people on how to handle certain issues. Have them understand, and you may have to counsel with them individually, what are the parameters of their relative position as a public educator. Much different than in private school, much different than in colleges. And so as long as they understand those parameters, and you understand those parameters, and I can tell you that this goes a long way, not only with regard to academic issues, but also student safety issues, expectations with regard to student behavior, how teachers are to respond to student behavior, how teachers are to respond to circumstances when they suspect that a child is being subject to abuse in some manner. We have a statute, 28711, which requires teachers, administrators to report to law enforcement anytime they think a child is being abused. I have a recent case where there's an administrator who did not understand the current law with regard to hazing, and hazing done by a sports team. You need to understand what those laws are and then convey them to your teachers. And those teachers then should, and in most cases will, abide by those directives. But people have to be reminded you need to do things on a regular basis. I'm a very strong advocate for when you do your teacher in-services at the beginning of the year, or do teachers' meetings, that you pick out some of these subjects and provide guidance to them on a myriad of these issues. I mean, in this short opportunity that we have to talk together today, I can't go through all of those issues, but I can tell you that you have board policies. One thing I would tell you as administrators, get out your board policies and read them.
Mm-hmm.
Board policies generally are organized in a manner, and particularly in a manner that you should focus on the ones with regard to curriculum and instruction, with regard to students, with regard to personnel. You need to read them and know them and have them available as a tool, because they are a tool to you. I'm amazed at how often administrators have not read, don't understand, don't reference their policies. So those are things that can help you guide your staff.
How often would you say most school districts have an attorney review their policies?
Well, it depends on the school.
Yeah,
I would say not very often. Although our firm has a policy template that we developed as a basis, and we have many schools, I can't give you the number, that have just adopted our template. The other thing that our office does, this is not a paid advertisement, but we every year update policies.
Yeah.
We update them through the educational service units throughout the state. Every educational service unit receives our policy updates and then sends them out to every school in the state. And I would tell you that I would want to get my hands on those updated policies every year and look at them, even if I'm a building principal. A lot of times we have boards adopt policies, they adopt the new policies, the superintendent secretary puts them in the policy book and nobody looks at them.
Right.
Those policies are updated because legislation has changed. The legislature has made a decision, we're going to address an issue. For example, the bullying statute was put in about 3 years ago. The school districts were required to have a bullying policy. That's a policy that every administrator should know and review with their staff. How do we react to bullying? And how do you document it? And what do you do discipline-wise with regard to bullying? Those things are all in your policy. You need to know what they say.
Yeah, my recommendation to new superintendents and principals also is to, when they first take a position, make sure they check those policies out, and then the annual review of changes. I think it's really important for them to be involved with or to have done. Sometimes you'll have conflicting board policies. I've run into that when I first took the position.
And if an administrator runs into a conflicting board policy, you need to go to your superintendent, or if you're a superintendent, you take it to the board and say, we need to fix this.
Right.
And sometimes you'll have policies that were written in a manner by someone who really hasn't thought through the legal ramifications of it, that place your school district in a disadvantageous position, and then those need to be corrected.
Right. And, smaller schools, there's some borrowed policies that sometimes I know I stepped in a position where there was no dates for when the policies were adopted, and then they were conflicting. One that I remember is there will be no corporal punishment, and another place that said when a corporal punishment occurs, it'll be done by an administrator. So obviously
that was drafted sometimes in the mid 1960s when my dad, who was a principal, was still using a paddle.
Yeah.
So I don't think you're going to do that. But I would say this to you also: don't be afraid of statutes. Many policies, our policies, all have a statutory reference. If there's a statutory reference, get a Nebraska school law book or get on Nebraska unicameral .org or .us or whatever it is, and look up the statute and read it. It's important to know what statutes say and understand statutes. I always tell school administrators, if you don't do anything else, if you're a school administrator, you need to read 79-828. You're going to say, what's that? And I'm going to tell you that is the statute that governs the evaluation of probationary teachers, but gives you the methodology that should be applied to all teachers. That is also mandated in Rule 10. So in Rule 10, it involves accreditation and involves both, and has a regulation that involves evaluation of both tenured and probationary teachers.
Speaking of evaluation, one of the questions I had, and we don't have to spend a lot of time on it, but can a district require a teacher to use a particular adopted teaching model?
Yes, absolutely, and should.
Yeah.
As a teacher, I can tell you that I grew up in the Madeline Hunter framework, the ITIP model. Teachers need a base to go from. If we're going to believe that teaching is a science, and most authorities believe teaching is a science, I believe teaching is a science, there are elements that should be in every lesson or in every teaching of a unit. I kind of, being an old person, am stuck on the ITIP model, but you have Danielson, you have Marzano models out there, all of which have some of the basic tenets and basic structures. But first of all, can you require a teacher to use a specific teaching model? The answer is yes. That specific teaching model should be in service to your staff. As far as documentation, when we get into working on personnel matters, your evaluation instrument should be based on an instructional model. You should in-service your teachers with regard to that instructional model, how it applies, what you need to see. And in my opinion, you need to have a lesson plan model that follows your instructional model. So can you require it? Yes. From a pedagogy point of view, that's a fancy word. I always thought pedagogy was a great word. From an instructional teaching point of view, I think it's essential. Now, does that mean that you can't be creative and vary from that? No. It's a structure, it's a framework upon which to build lessons, but it does provide consistency, and it provides a baseline for your teachers, particularly young teachers as they grow.
These are questions that some students submitted from previous lessons. One of the things is, can a school district set a standard for teacher attire?
I think the answer to that is yes. This goes along, I suppose, with a little bit of the free speech and stuff. But yeah, I think you can set a standard for that. It's one that I think sometimes gets loosely applied. I can even tell you 40 years ago, as a coach, I didn't always show up in a shirt and tie because I had a basketball game to coach. But yeah, can you have standards for teacher attire? Yes.
You know, I had an attorney once tell me that we're talking about teacher attire. One of my principals was pretty strong on teacher attire, another one wasn't. And he told me it was basically, even though it's a board policy, it was a building decision. Do you have any thought about that? Or?
Well, okay. I'm going to digress a little bit on that. It can be a building decision. What I would say is having a standard expectation across the district eliminates some issues and some problems. But then again, if you have site-based management, I guess those decisions can be made. I think what it really comes down to is a matter of boundaries. And I'm going to digress over into a little bit of a boundary policy. But one of the things that sometimes we run into issues with teachers is establishing the boundary between teacher-student relationships, particularly at the secondary level. In attire, demeanor, approach, those things allow teachers to establish the necessary boundaries between themselves and the students that they instruct. So yeah, you can have differences in standards. I would tell you that being consistent building to building, if you were in a multi-site school district, being consistent with regard to the application of policies, procedures, expectations is important as staff flows between buildings, as expectations for the entire district are considered when people come to a boards of education would rather not have to deal with one school being different than the other. I think the other thing is, and this came up a couple of years ago with regard to a fairly large district, was what is the expectation of performance by teachers? They had an instructional model. The instructional model was basically rated teachers on beginning, basic, and proficient. Mm-hmm. And so I asked the administrators there, about 20 of them, I said, all right, how many of you believe that meeting the district standard of performance expected of a teacher is achieved at the basic level? Okay. In other words, if you're at the basic level, have you met the standard? Well, the answer is no. So everybody raised their hand and said no. I said, how many of you think you've met the standard of performance if you were at the, and I can't remember what I just said, but at the next level, which was
proficient, probably, I think.
Well, not proficient, but anyway, the bottom line was this: half of them raised their hand, and we didn't have a consistent determination of what constituted meeting the district standard of performance. So you need to make sure that you do that, because you don't want one school saying that this standard meets the level of performance and the other school does not.
Yeah. What about teachers that may have a questionable lifestyle? How do you determine whether anything can be done about it, or we'll say unmarried teachers living together? Is there anything that, how would you approach that, or do you approach it?
Well, what it comes down to is another kind of fancy legal word, which is nexus. If you're going to act and discipline with regard to off-school grounds, private time conduct, you're going to have to establish that there's some connection between the teacher's conduct and their job. 50, 60, 70 years ago, that really wasn't an issue. I mean, pregnant women couldn't teach. That was a rule that was enforced many years ago. What I would tell you is only if that lifestyle impacts their ability to perform their duties and you can establish a connection or a nexus between that conduct. And one of the things to remember is that the key element to any employee is whether or not they are performing the essential functions of their job. Now, you're going to have circumstances. I just had this circumstance earlier this week where a superintendent called me to tell me they had a teacher whose health seemed to be declining because of choices that person was making with regard to their lives. And the question was as well, what should we do about that? Well, you can counsel with them with regard to how they're feeling, but you do not want to get into a position where you're intrusive. Remember that you're not a social worker, you're not a psychologist, you're not a physician. You're an employer expecting somebody to do a job. So if they have a questionable lifestyle, are they bringing that questionable lifestyle into your school? Now, if that questionable lifestyle involves being convicted of drug use or criminal conduct, obviously that has a nexus to their job, particularly if they are in a circumstance as an exemplar. So the answer is yes, if their lifestyle impacts their ability to do their job, and that includes being an exemplar to students. One of the questions that Dr. Nelson has here is what can be done if a teacher is charged with DUI? Well, I can tell you that we've had those cases, and courts have addressed those issues, either in this state or in other states. And it comes down to the nexus connection. If that instructor is a secondary teacher who is instructing secondary students, and drug and alcohol issues are an issue in a high school, which is true of almost every high school, that probably is a sufficient nexus for some sort of discipline, including non-renewal, termination, or cancellation. I'm going to come back to those three terms in a minute.
One of the cases that I talk to students a little about involving nexus or lack of nexus is the Erb versus the Iowa Board of Instruction, whatever it was, and it was really an adulterous situation, and yet the courts ruled that that was not an effect of his ability to teach. Sometimes in a small town, you'll get these comments from citizens, and I just think that's a case to remind yourself that it does have to have a nexus. And
it does have to have a nexus and a connection. That doesn't set aside the politics of any personnel decision. And the politics of personnel decisions can be pretty divisive, particularly in small communities. And what you may consider to be the standard that should be applied, others may not agree simply because of who the person is, and they're standing in the community, and they're a longtime coach who does an abusive thing to a student, and the community says, well, the student deserved it. Well, that's really not the standard anymore. Yeah. But you have to determine when you're going to call the ball on what you're going to do with regard to it. But remember that you need to be consistent, and your board needs to be reminded that you need to be consistent. We live in this world of push and shove on what is political correctness and what is not. And what I would tell you is that your backstop is the law. We have determined in this state and in this country that certain conduct is not going to be tolerated, even though somebody may say it's boys will be boys. We have an anti-bullying statute. We have harassment, discrimination, intimidation statutes that are either in student discipline laws or in federal laws, Title IV, Title VI, Title IX, or whatever they may be. Those are expected to be enforced, even if the rest of the community may not think that should be the case. We're dealing a lot with certain use of racial epithets and stuff with regard to certain communities who come in and compete in activities. The bottom line is what's the school's responsibility? The school's responsibility is to provide a safe learning environment for everybody, even students who are visiting your school. Mm-hmm. So those are tough issues that administrators have to face, and that comes down to responsibility for education. But going back to the DUI issue, the case in New Mexico, a New Mexican Supreme Court determined that an elementary teacher who got a DUI should not have been subject to termination, stating that the students that she taught, which were first or second graders, are not impacted by a teacher getting picked up for DUI. I will tell you that in most cases for secondary teachers, a DUI, it's probably not the first strike, you're probably not out, but the second strike, you probably are. So that's an interesting issue.
Before we, I know you were going to mention about non-renewal and termination. We have one question that really did happen, and I always am interested in how students respond to it. The high school senior English teacher who's a topless dancer at a juice bar, and the students, the 18-year-olds, can actually go to that bar. How would you handle that as an administrator? Can you legally do anything about that?
All right, well, that's the nexus issue.
Yeah.
I mean, that's really a nexus issue. And then that gets into the issue of community standards of conduct and the nature of the activity. I would tell you that if I had a high school teacher, I'm assuming it's a female teacher under that description, who was a topless dancer in the community in which she taught or within a reasonable geographic area. I mean, if she's driving 200 miles to go do it, I suppose it may be different in a matter of location. That may be her off-duty job, but the mores of our community would indicate that probably is not consistent with what we would expect of our staff. And the question then is, does it fall within the just cause elements for termination at the end of a contract or cancellation during a contract? And so those elements are, well, is it insubordinate? I don't know, maybe unprofessional.
Hopefully, you would hope that a conversation might convince that teacher that that wasn't the place to be. We also, as a side note, we asked the question, if it's a 18-year-old senior girl, what can you do? Basically, I don't think there's anything you can do. And
18-year-old senior girl is dancing topless. That's her private business. She's coming to your school under the compulsory attendance law, is required to provide to provide an education to that student. There are a myriad of issues with that, and I'm not going to go too far with that.
Probably wouldn't get into National Honor Society, but who knows?
Well, I don't know. Why not?
Why not? Okay.
I mean, that's her academic. This is all based on academics. She could get into National Honor Society, I suppose, if she could meet the criteria for National Honor Society. Again, sometimes you need to take a step back as an administrator and look at students as they are and provide rules consistently. So,
and one of the comments that students usually say is you really can't take the right for them to make a living away from them, as long as it's outside of school hours. But let's talk just a little bit about some Nebraska cases. And one of the things I had mentioned is the April 15th. Why is that so important?
Well, April 15th is the date by which statutorily a school district must give notice to a certificated employee of the ending of the employment relationship at the end of the contract year, meaning for the year in which they are employed, either by reason of non-renewal or termination, or termination or non-renewal by reason of reduction in force. So those are the really three that the April 15th date applies to. So let's talk about what non-renewal is. I mentioned 79-828. As you all know, a teacher is a probationary employee whose employment may be non-renewed for any reason that the Board of Education deems sufficient during the probationary period, which is 3 years or a total of successive years of teaching that add up to 3 years. So our courts have held that if you're a 0.5 FTE teacher, it's going to take you 6 years to achieve permanent status. Remember that if you hire somebody at halfway through a school year, they're not going to achieve permanent status until they've taught 4 years. So remember to go count to determine whether or not they're probationary. Termination means the ending of the employment of a permanent teacher or tenured teacher by reason of just cause. Just cause is unprofessional conduct, neglect of duty, insubordination, incompetency, immorality, or other conduct which substantially interferes with the continued performance of duties, which is kind of a catch-all at the end of that. So you have to have just cause to terminate a teacher's contract at the end of the contract year. Cancellation is the ending of employment during the contract year, and cancellation applies to both tenured and probationary employees. So if I have a first-year teacher who's not performing or who does something that would be grievable, let's see, bad enough,
egregious,
to get their contract canceled, that's for just cause. Again, just cause are those things, elements I just pointed out to you. April 15th is significant, and I would tell you as administrators or young administrators that April 15th is important for a lot of reasons, and not just the date. April 15th should be a date that you keep in mind as you work with your staff to improve their performance. And that brings in the concept of evaluation, observation, summative evaluations, formative evaluations. Your goal is to make sure that as you approach April 15th, that one, for probationary teachers, you have evaluated once in the first semester, and that means observed and evaluated. And evaluated means evaluation of their entire performance, which under Rule 10 is to include both their classroom management, their instruction and planning, their professional conduct, and their personal conduct. And those latter two, professional conduct and personal conduct, cannot be, or generally are not, evaluated as part of an observation. One of the things that's problematic when I get documentation from administrators is I say, well, have you observed and evaluated once each semester? And what I get is an observation, not an evaluation.
Mm-hmm.
Okay, so you need both an observation and a summative evaluation. And summative is all the elements, a full formal evaluation on your evaluation form that's been on file with the Department of Education, which you should have in-serviced your staff on at the beginning of the school year. And that should happen with probationary people once each semester, and certainly well before April 15th. I have had circumstances where principals give a probationary teacher, or a tenured teacher for that matter, their evaluation on April 15th, and then hand them a non-renewal letter. Well, that doesn't work, okay? And if you send that to me, I'm going to tell you that that doesn't work. And that's because 79.828 requires you to observe, evaluate, identify deficiencies, provide assistance in overcoming the deficiencies, and follow-up evaluations. If you hand them an evaluation on April 15th and give them a letter, you certainly haven't complied with that statute. The other issue with April 15th is this. I'm on the phone.
Okay.
Sorry, I got a phone call.
That's right.
We have case law that says this. If you have not given the letter by April 15th, that you're going to terminate or non-renew. Terminator, I got people coming in my office now. Terminate or non-renew, and you don't give the letter by April 15th, you are not going to be able to terminate or non-renew them until the next year, unless there is conduct which would give you reason to cancel their contract. And if you decide in May 15th that you want to end their employment, you have to have just cause. And that just cause must have been an incident that occurred after April 15th. So you can't, well, change my mind without any further evidence or documentation. Well, I just decided that, you know what, I want to end this person's employment, but it's after April 15th. No, that has to be a cancellation.
Right.
So that's why it's important. And the answer is, yeah, you can cancel them after April 15th, but you have to cancel. And that constitutes a just cause hearing.
Yeah. When you send that letter or give that letter to that teacher, does it say, I'm recommending the board consider your termination? Is somebody told me consider should be in that letter? Is that?
Yeah, well, the board's going to consider it. We're recommending to the board. You could say recommending to the board that your contract be terminated, non-renewed, canceled. But it goes without saying the board's going to consider it.
Right.
And you have to, and the board should, except I suppose in probationary situations, not be involved in the evaluation of that teacher, notwithstanding the fact they may call you and talk to you about it and say, I had this parent call me and say, Mrs. Smith is horrible. Well, they should be told to refer it to you that you have to deal with it because the board has to be the adjudicator at some point in time. And they have to be a neutral adjudicator deciding the case involving cancellation or termination based on the evidence that is presented. What I would tell you is my approach to any termination or cancellation, or even for that matter, non-renewal, is when I give them the letter, I also give them a notebook which has all of the documentation that supports the recommendation for either non-renewal, termination, or cancellation. By statute, I don't need to give them that until 5 days prior to the hearing, but I always give it at the time that I'm giving them the letter, and that's only human relations. It's losing your job. There's hardly anything worse than losing your job other than a divorce or a death of a family member or a death of somebody close to you. Your reactions are similar: anger, disbelief, humiliation, all of those things, and you need to give people plenty of time to deal with that.
One of the things that I found is, I think goes along with what you're saying, is giving that teacher that information when you give them the letter sometimes helps them decide not to have a hearing, that there's enough.
Well, I will tell you that since we've started that practice, I haven't had a hearing.
Yeah, that's what.
And probably I've had hearings, but not hearings over that kind of thing for about 10 years. We work closely with the NSCA attorneys. They understand what it's going to be like, what it's going to go through, how many hours it's going to take, and the end result that they're going to achieve. And so we usually work things out.
Good. Well, I think we've basically answered the questions that I gave you. I really appreciate your expertise on this and helping students always comment about it. They enjoy the videos. They have commented about your videos that they've gotten.
And at least my dress is a little more updated than
yeah, we are. I guess I look about the same.
Actually, you compare the two, I probably look a lot older too. So that's
no. Well, I'm gonna let you go and stop recording here and.
Okay. Well, thank you. Thanks. Fun.
Well, thank.